Alright people, so welcome to Jumbo IS and welcome to lecture number 8 from Polity in this lecture series called Prelims Powerplay 2026. Through this lecture series, as you all know by now, that we are revising the entire syllabus for Prelims 2026 examination, the entire syllabus. So that includes our current affairs portion as well as the associated static topics. The associated static topics, because static topics which have some connection with current affairs have a higher chance of featuring in your prelims examination. Therefore, we will try to cover those important static topics as well. Plus, current affairs is being covered subject-wise. Okay? Now, if you really want to get the advantage of this lecture series, well, you'll have to follow these 4 steps. Step number 1 is, well, watch the lecture on time. Okay? Don't keep lectures pending. Step number 2 is, memorize the notes that we are providing you, because your notes contain some extra information as well, some information that is not covered in lectures but is pretty self-explanatory. So do that as well, memorize the notes. Then step number 3, we have enrolled you in our WhatsApp groups. Those groups are created for your doubts, so use those groups judiciously. Okay, ask your doubts as soon as they occur to you. And step number 4, along with this lecture series, we are providing you access to our test series as well. Be regular with the tests. It is very important. You cannot clear prelims examination without adequate MCQ and test practice. So be regular with the tests as well. That is the most critical component of your preparation. Okay, all right then. Enough of the introduction. Let's straight away jump into the lecture. But first, let's take a look at the topic that we are going to cover. Okay, so our today's topic of discussion would be legal aid in India. Now, why are we discussing legal aid? Well, because November 9th, this year, I mean the previous year, 2025, on November 9th, Legal Services Authority of India, well, basically completed its 30 years. And that is why we celebrate Legal Aid Day in India on November 9th. So remember this, these facts are mentioned in your notes. Now, it becomes important for us to understand the concept of legal aid in India and what constitutional provisions are there with respect to legal aid in India, and what sort of advantages, challenges, all these things are there. Okay, so this lecture will contain a lot of facts which are relevant for prelims. So pay close attention and let's begin. Okay, so Polity lecture number 8, legal aid in India. So yeah, what is the definition of legal aid, or what is legal aid basically? So legal aid in India means providing free legal services. Okay, because you see, the thing is, our constitution wants that everyone should get justice. Okay, now justice is provided in India's courts, and in these courts, well, you need lawyers to represent you. But most of the times, good lawyers are expensive. Sometimes all lawyers are expensive, and some people can't even afford a lawyer that has a very low fees also. People can't afford the services of a lawyer, right? Now, these people won't be provided, these people won't get access to justice because they can't afford any lawyer. Now, if this is the situation, then Government of India is not performing its duty properly, because we want to provide justice to all. This is the constitutional duty, right? So if there are people who cannot afford legal services because of economic disabilities, well, it will be the job of the government to provide legal services to these people. Okay, and this is legal aid in India, so that justice is not denied because of economic disabilities. You understand the gist of the matter now? All right, so now let's move forward. So it means providing free legal services, including advice, representation, and other legal assistance to persons who cannot afford them, so that poverty or disadvantage does not become a barrier to justice. Okay, now in India, this evolved from colonial era and early post-independence schemes. So earlier, this was being provided through various government schemes. Even in colonial era also, some provincial governments were providing this. Okay, to a full constitutional mandate in Article 39A. In 1976, Article 39A was inserted in the Constitution, which basically says that government shall strive to provide free legal aid. Now, as you can see, 39A makes it a DPSP, Directive Principle of State Policy. Yes, so Directive Principle of State Policy is not mandatory, yet it gives a moral obligation on the state to provide free legal aid to every person in India. Not every person, but those who can't afford it. Okay, and statutory framework under, and to basically implement Article 39A, Legal Services Authorities Act was passed, which will ensure free legal aid. Okay, So to implement Article 39A, Legal Services Authorities Act was passed, and this act was enforced on 9th November 1995. And it has been 30 years, so 9th November marks the 30th anniversary of implementation of Legal Services Authorities Act. Okay, now let's dive a little deep into the concept of legal aid. So about legal aid, okay. So Article 39A inserted by 42nd Constitutional Amendment Act, so remember this, okay, directs the state to provide free legal aid by suitable legislation or schemes to ensure that justice is not denied due to economic problems or economic disabilities, okay. But remember, Article 39A nevertheless is a DPSP. So through 42nd Amendment Act, the framers of 42nd Amendment Act, well, a moral obligation was put on the governments to implement this, but it was not a legal obligation, as DPSPs are non-justiciable. Yet, government passed Legal Services Authorities Act, okay, and then it became a legal obligation because of this law. But eventually in 1987, Supreme Court even made it a constitutional obligation, because Supreme Court said, not in 1987, sorry, even before that, in 1979 only, the Supreme Court said that access to legal services is part of right to life under Article 21. So Supreme Court in 1979 made it a fundamental right or part of fundamental right. As you know, Article 21 contains so many fundamental rights, right to privacy, everything is under Article 21. So right to free legal aid was also made a fundamental right by Supreme Court in Article 21. To implement this, Legal Services Authorities Act was passed. And under Legal Services Authorities Act, there was a three-tier structure that was formed. National authority at national level, state and district legal services authorities, and then taluk and tehsil bodies for institutional delivery of legal aid. We'll talk about this three-tier structure. It's given in your notes as well. Okay. Now, what are the, because MCQs can be asked, that is why the next slide was put in, specifically inserted by me, okay, because they might ask questions related to the constitutional provisions that support the idea of legal aid, okay. So constitutional provisions that support the idea of legal aid, first of all, it is very simple, Article 39A inserted through 42nd Amendment Act, okay. Then Article 21, this was done by the Honorable Supreme Court in Hussainera Khatun versus State of Bihar case, that legal services should be part of right to life under Article 21. Then Article 14 is also somehow related to free legal aid. How? And this is important because they can ask an MCQ and you might think that only Article 39A and 21 are related to legal aid. Okay? But no, if they give which of the following, if this is the MCQ, which of the following articles of the Constitution are related to free legal aid? And they'll write Article 39A, 21A, 14, 22. You'll mark 1 and 2 only. But the answer would have been 1, 2, 3, 4. That is why this slide was inserted. Okay? So Article 14 says, no person shall be denied equality before law and equal protection of law. But you won't get equal protection of law because you don't or you cannot afford the services of a lawyer. So you won't be protected by law because you can't afford a lawyer. That would be violation of Article 14 because a rich person will get justice because of law, but poor person cannot. So Article 14 is there. This is violation of Article right to equality. Then Article 22 also mentions that, well, an arrested person has the right to be represented by a lawyer. So it gets a cursory mention in Article 22, but Article 14, 21, 39A are definitely there. And even 22 is also there because it specifically says that arrested people have the right to free legal practitioner. If you can afford it, well, you have to pay it from your own pocket. But if you cannot afford it, then the state will provide that for you, a lawyer for you. Okay, makes sense? Simple? Okay. Now, to implement these constitutional provisions, to implement the promise under Article 39A, well, Legal Services Authorities Act, Legal Services Act was passed in 1987. The Act established a three-tier system to provide free and competent legal service. Okay. At national level, there was National Legal Services Authority, which is headed by Chief Justice of India. So remember this. At state level, State Legal Services Authorities headed by Chief Justice of a High Court. And the third tier, District Legal Services Authorities headed by a district judge. Okay, these authorities will ensure that legal aid is provided to poor people. Okay, at national level, the policy making would be done by NALSA. At state level, SALSA or SLSA and DALSA or DLSA will ensure that free legal aid is provided in that particular district. You understand my point, right? Now, not key features, but who are eligible. Who all are eligible for free legal aid? Remember, this free legal aid is provided to people who cannot afford legal services, right? So this shouldn't be provided to rich people. So there should be a beneficiary list for this, okay? Who all are eligible for free legal aid? Rich people shouldn't be eligible. So who all are eligible? SC/ST members are eligible. Women and children are eligible, because in India, in a patriarchal society, women generally don't work. So from that perspective, now women do work, but some women in India are still living in a patriarchal society. Some women. So for them, they might not be able to afford a lawyer independently. So that is why women and children are included. Children, of course, are not economic citizens. Then victims of trafficking or disaster, human trafficking, the natural disasters, mentally ill and disabled, and others also. Industrial workmen, persons in custody. Okay, those with income below 5 lakh for Supreme Court cases, and every state will decide for High Court. So states can decide the threshold for eligibility under the Act, which varies from 1 lakh to 3 lakh in High Court. But for Supreme Court, if your income is less than, annual income is less than 5 lakh, for Supreme Court cases, you are eligible for free legal aid. Make sense? Okay. All right. Now, let's talk about NALSA for a minute. Key functions of NALSA. All right. Now, these are the key functions of NALSA. So, formulation of policy. I mean, what should be the policy so that legal aid is more accessible? Okay. So, this is the policy level. Then fund disbursement, because those lawyers that are being provided to you would be paid. You won't pay for them, but state would pay for them. So state requires funds for that. So fund disbursement, free legal services, lok adalats also. Lok adalats are for resolution of disputes through mediation. Okay. Then legal awareness, a budget is basically kept separate for generating awareness. Then monitoring and evaluation, special invitees, these are given in your notes. These functions are given in your notes, so do go through them. Okay. And now we'll talk about the last topic as far as legal aid in India is concerned. Let's quickly finish this, and that is challenges. Despite this act being enforced since 1995, it has been 30 years, still access to legal services is a problem in India. Not everyone is getting access to legal services, plus those who are, well, the lawyers are of extremely poor quality. That's the complaint that is generally expressed by people. Okay. So challenges are still there. Justice is still not completely accessible. It's a journey. Okay, we'll reach there one day, but currently we have not reached to that place where justice is not denied because of lack of economic or is not denied because of economic disabilities. Okay. Now, what are the challenges? Lack of awareness. Some people are not even aware that government will provide a lawyer for them. Lack of awareness, legal literacy, as per NALSA report. Then substandard quality of lawyers that is provided by the state. Okay, this is the biggest complaint. Then underfunding. The department is underfunded, and limited physical outreach. One lawyer for every 10,000 people in rural India versus one for every 1,000 in urban areas. This shows a clear-cut rural-urban divide. That there is one lawyer for 10,000 people in rural India and one lawyer for 1,000 people in urban areas. That means you are favoring urban people more than rural people. So this is a huge challenge. All right. And that's all the information that you need. That's all as far as today's lecture is concerned. By the way, do not forget to watch the lecture, which you have already done so, but memorize the lecture from the notes. Okay. And ask your doubts if you have any. And the test is about to come. Only 2 lectures are left, and then the polity test would come. So be regular with the test and give the test. Okay. And on that note, I'll be taking your leave. Thank you so much for watching, everyone. And I'm sure it is adding value to your preparation. But continue with it. Stay consistent with it. And I shall take your leave with the promise of seeing you again with another topic in this lecture series called Prelims Powerplay. Thank you, everyone.